Now that your mediation session has concluded, let's discuss what to expect next, including common reactions you may experience and the practical steps ahead.
Here are the possible outcomes of a mediation session with some examples. 1. Full agreement reached. The parties resolve all disputed issues and reach a complete settlement. Here's an example of a full agreement.
The mediation of a neighbor fence dispute. Two neighbors disagreed about a shared fence. In mediation, they agreed that neighbor A would pay $1,500 toward a new fence. Neighbor B would hire the contractor. The fence would be 6 feet tall, cedar, and it would be installed by June 30th. Both signed the agreement, and the fence was built as planned.
2. Partial agreement. The parties agree on some issues, but not others, leaving remaining disputes to be resolved through other means. Here is an example of a partial agreement.
A divorce mediation. A divorcing couple agreed on child custody, 50-50 shared custody alternating weeks, and division of the family home, sell and split proceeds equally. However, they couldn't agree on spousal support amounts or division of retirement accounts. They finalized custody and home agreements, but will go to court for a judge to decide the financial issues.
3. No agreement. Impasse. The parties cannot reach any agreement, and the mediation ends without resolution. 4. Agreement to continue. The parties make progress but need more time, so they schedule additional mediation sessions. Here's an example of an agreement to continue.
A business partnership dissolution. Two business partners wanted to split their company, but they couldn't agree on the business valuation. They agreed to hire an independent appraiser within 30 days, then returned to mediation once they had the valuation report. They scheduled their next mediation session for 6 weeks later.
5. Agreement in principle. The parties agree on major terms, but need time to work out details or consult with advisors before finalizing. Here's an example of an agreement in principle.
A personal injury settlement. An accident victim and insurance company agreed the settlement would be $75,000 total. However, the victim needed to consult with their financial advisor about structuring the payment, lump sum versus structured settlement, for tax purposes. And the insurance company needed approval from the regional office. They agreed to finalize paperwork within 2 weeks.
A successful mediation provides satisfaction that goes beyond the final terms. It's rooted in both procedural fairness and the emotional process itself. When parties feel heard, respected, and safe enough to address underlying emotional issues, they achieve a deeper sense of closure and fairness, even when the agreement involves compromise. Ideally, you've also gained new respect and understanding for the other party. What may happen if you reached an agreement? Even with a resolution, your feelings after mediation may be complex. You might feel relief and closure, knowing you've avoided the uncertainty and cost of a prolonged court battle. However, some discomfort is also common. Mediation typically involves compromise, meaning you likely didn't get everything you initially wanted. This ambivalence is a natural part of the process. You've made a decision you can live with, rather than achieving a complete win or absorbing a total loss. As you process the outcome, consider focusing on the value of resolution. Look beyond the specific terms to recognize that the broader benefits, time saved, money saved on future legal fees, emotional closure, and potentially preserved relationships. What may happen if you didn't reach a final agreement? Even without a final agreement, your mediation session was not a failure. You likely achieved significant progress. Emotional progress, the process provided a safe space to air grievances and have your perspective heard, an important step towards emotional closure and moving past the conflict. Practical progress, you clarified the issues, exchanged information, and forced both sides to realistically assess their cases. This constructive dialogue narrows the gap between you and prepares you for the next step, whether that's future negotiation or trial. Regardless of the outcome, it's normal to experience relief that the mediation session itself is over, uncertainty about whether you made the right decisions, exhaustion from the emotional intensity of negotiation, frustration if you didn't get everything you wanted, anxiety about next steps in implementation. These feelings are valid and common. Give yourself time to process the experience before making any major decisions about your next moves.
A question I often get when parties come to an agreement is, what happens if they don't honor the contract? There are multiple cases to consider. For a private mediation, non-court linked, when parties voluntarily engage in private mediation without court involvement, the resulting agreement is enforceable as a standard contract under contract law principles. A party seeking to enforce the agreement must file a lawsuit for breach of contract in civil court. Court-ordered or court-referred mediation enforceability differs depending on case types. Mediation agreements in family law cases like divorce, custody, and support matters typically become enforceable court orders once approved by a judge. These agreements carry the strongest enforcement mechanisms, including contempt proceedings for violations. In civil litigation cases, settlement agreements reached through court-ordered mediation are generally enforceable as contracts. To gain the additional enforcement power of a court order, parties must file the agreement with the court as a stipulated judgment or consent decree. Without this step, enforcement requires filing a separate breach of contract lawsuit. In small claims cases, mediated settlements are often immediately entered as binding judgments by the court, giving them direct enforceability without additional procedures. This streamlined approach reflects the simplified nature of small claims proceedings. The specific procedures vary by state and local court rules, so check the process for your specific case and jurisdiction. Contact your attorney or reach out to the clerk's office at the court where your case was filed. Mediated agreements typically show 60 to 80% voluntary compliance rates compared to court orders at 40 to 60%. This higher compliance occurs because parties voluntarily came to the mediation table and crafted their own solutions rather than having terms imposed on them. Since both sides had input, they understand exactly what they agreed to and why. As a result, the terms feel fairer and reflect their real-world constraints. Additionally, parties who choose mediation are often motivated to preserve their ongoing relationships.
Now let's talk about the next steps after your mediation session. Your mediator and attorney will walk you through them, but here is a general idea. These actions depend on the outcome of your mediation. If you reached full or partial agreement, your next steps could be 1. Finalizing the documentation. The mediator may not have completed the agreement during the session itself, especially if the mediation ran late or the terms were complex. In such cases, the mediator will draft the agreement and circulate it to all parties for review and signature. 2. Have a legal review. If your attorneys were not present during mediation, they will need to review the agreement before you sign to ensure the terms are legally sound, protect your interests, and are enforceable. 3. Court filing, if applicable. If your dispute is part of ongoing litigation, the agreement typically must be filed with the court. Depending on the terms and local court rules, this may result in the case being dismissed, judgment entered based on the settlement, or the litigation staying open while you implement the agreement. Contact your attorney or the court clerk's office where your case was filed for specific guidance. 4. Implementing the agreement. Both parties are legally obligated to follow through on the agreement according to the timeline and terms specified. This might include making payments, transferring property, completing specific actions, or refraining from certain behaviors. Mark deadlines on your calendar and ensure you have a plan to meet each obligation. Here are some additional steps for partial agreement. If you resolved some issues but not others, the remaining disputes must be clearly identified and documented. You and the other party or your attorneys will need to decide how to address unresolved issues. Options include
returning to litigation and having a judge decide the remaining matters, scheduling another mediation session to continue negotiations, proceeding to arbitration for binding resolution outside of court, pursuing other alternative dispute resolution methods, continuing direct negotiation through attorneys. The issues you did resolve are typically implemented immediately, even while you work on the remaining disputes. What if you reached no agreement? When mediation doesn't result in settlement, you have several paths forward. 1. Litigation options. File a lawsuit if you haven't already initiated court proceedings. Return to litigation if your case is already in the court system. Resume discovery. File necessary motions and prepare for trial. Consult with your attorney about the strength of your case and realistic trial outcomes given what you learned in mediation. 2. You may try alternative approaches. Consider arbitration as a faster, more private alternative to court trial, where a neutral arbitrator makes a binding decision. Continue direct negotiation through attorneys without a mediator facilitating. Reassess your position after some time has passed. Many parties gain new perspective after experiencing the mediation process and may be more willing to compromise later. You may also try mediation again in the future, potentially with a different mediator or after additional information becomes available. Remember, attempting mediation doesn't weaken your legal position, and discussions from the mediation session remain confidential and generally cannot be used against you in court. If you reached an agreement in principle, there would be additional steps. An agreement in principle means you've settled on the major terms but need time to work out details or obtain approvals before finalizing. Additional steps include due diligence and approvals, conduct any necessary due diligence, such as property inspections, financial reviews, or tax consultations to ensure the agreement makes sense for your situation, obtain required approvals from boards, companies, or institutions involved in implementing the agreement, finalizing specific terms. Work with your attorney to translate broad principles into precise legal language. Nail down specifics like exact payment schedules, deadlines for each obligation, contingencies that might affect the agreement, and what happens if someone doesn't comply. Stakeholder review. Share the agreement with anyone whose approval or cooperation you need but wasn't present at mediation, such as family members, business partners, co-owners, insurance companies, or financial advisors. 4. Execution and timeline. Once all details are finalized and approvals obtained, execute the formal written agreement with all necessary signatures. Establish a clear timeline for moving from principle to full execution, including checkpoints to monitor progress and ensure both parties are moving forward as expected. In all cases, maintain confidentiality protections established during mediation. Document what was agreed to or not agreed to prevent future disputes about the mediation process, and don't hesitate to contact your mediator, attorney, or the court clerk's office if you have questions about your specific next steps.
Let's talk about confidentiality post-mediation. It's crucial to remember that while the final mediation agreement may become a public court record once filed, the discussions, negotiations, and communications that occurred during the mediation process itself remain confidential and protected. This confidentiality is not merely a courtesy, it's a fundamental principle of mediation that is often protected by state law and the terms of your mediation agreement. You should not disclose what was said during mediation sessions, what offers were made or rejected, or the mediator's comments or suggestions to anyone outside the process, including friends, family, or on social media. Breaching mediation confidentiality can have serious consequences. It may expose you to legal liability, including potential lawsuits for breach of contract or violation of court orders. It could undermine the enforceability of the agreement itself. It may result in sanctions from the court, and it damages the integrity of the mediation process for everyone involved. Additionally, there might be a specific confidentiality clause in your agreement that you will need to honor to prevent a breach of contract. Also, if any party needs to return to mediation in the future for modifications or disputes, a breach of confidentiality can destroy the trust necessary for productive negotiations. Even years after mediation concludes, you remain bound by this confidentiality obligation unless all parties agree otherwise in writing or a court orders disclosure under very limited circumstances.
A few closing thoughts. As you move forward, make sure to keep your commitments. The agreement you reached is built on trust. Honor your obligations fully and on time. This is how you turn words on paper into lasting resolution. Lean on your support system. Stay connected with your attorney to finalize administrative details and navigate any questions that arise during implementation. And honor the process. The confidentiality of mediation protects everyone involved. Respect what was shared in that space. And be kind to yourself. Conflict resolution is exhausting work. Give yourself permission to rest, process your feelings, and recognize the strength it took to participate. Whether you reached full agreement or not, you engaged in a process designed to find common ground. That effort has value, and it moves you closer to resolution and peace. Recognize that the mediation process you've just completed required courage, vulnerability, and a willingness to work toward resolution. You've done difficult work. Now take time to care for yourself as you move forward.